A unanimous Supreme Court decision just dropped, and if you carry a firearm in your vehicle, or even have one locked in a case in your trunk, the legal ground beneath your feet just shifted in a way that affects every single traffic stop you will have for the rest of your life. We are talking about a 9-0 decision, not 5-4, not 6-3. Every justice, liberal and conservative, looked at the same set of facts and arrived at the same conclusion. And what they agreed on is going to shock you, protect you, or get you arrested, depending entirely on whether you keep watching the next few minutes or close this video right now. Here is what is at stake. If you carry legally, you have probably been operating under a set of assumptions about what police can and cannot do during a traffic stop. Some of those assumptions just got confirmed at the highest level, but some of the gaps in your knowledge, and almost every gun owner has them, just became more dangerous because the law has changed and officers on the ground have not all caught up yet. By the end of this video, you will know exactly what the court decided, why it matters, what you should say and do the next time blue lights appear in your mirror, and the 3 mistakes that gun owners make constantly that undo every legal protection they have. And I want to plant something in your mind right now that I'm going to come back to in a few minutes. There are 5 words that defense attorneys across the country want every gun owner to have memorized before they ever get behind the wheel. 5 specific words that create a legal record in the moment when it matters most. I will give you those words, I will explain exactly when and how to use them, and I will tell you the one thing most people do immediately after saying them that destroys all the protection they just created. That is coming. But first you need to understand what just happened in the Supreme Court and why the lower courts were so catastrophically wrong. Before we go further, do one thing right now. Subscribe and turn on the bell. Here is why that actually matters, and it is not the reason you think. The gun laws in this country are changing faster than at any point in the last 50 years. Court rulings, state legislature changes, federal policy shifts, they are happening constantly. And the overwhelming majority of gun owners only find out about these changes when it is too late, when they are already sitting in the back of a patrol car wondering what just happened. I do not want you to be that person. The information I am about to give you is powerful, but it has a shelf life. Subscribe now so you are there when the next update drops. Because in this legal environment, there will always be a next update. Now let us get into it. To understand why this Supreme Court ruling is so significant, you need to understand the disaster that was quietly building in the lower courts for years before this case ever reached the highest bench in the country. A legal theory had been growing across multiple states and multiple federal circuits. The theory went like this. When a person is stopped in a vehicle and a firearm is present, even a legal firearm, even one the driver had a valid permit for, that firearm represented an elevated threat. And because it represented an elevated threat, officers were justified in doing far more than a standard traffic stop allowed. More questions, more demands, and in many cases, a full warrantless search of the entire vehicle. On paper, some courts were packaging this idea inside existing legal doctrines about officer safety and reasonable suspicion. But what they were actually doing was something far more dangerous. They were quietly building a 2-tiered legal system where law-abiding gun owners lost one constitutional right the moment they exercised another one. Think carefully about what that looks like in practice. You are a legal gun owner. You have your permit. You have done everything right. You get pulled over for a broken tail light. You inform the officer, as the law in your state requires, that there is a firearm in your vehicle. And under these lower court interpretations, that single act of honest, law-abiding disclosure was sufficient legal authority for that officer to search your entire vehicle without a warrant, without evidence of any crime, without anything except the existence of the gun you legally own. That is not a hypothetical. That is what was actually happening in courtrooms across this country. And that is exactly what this Supreme Court just ended. The case that forced this issue originated in the Midwest. A man with a legal firearm, a valid concealed carry permit, and no criminal history was pulled over for a minor traffic infraction. He disclosed his firearm immediately and calmly, exactly the way he was supposed to. The officer then conducted a full search of the vehicle without a warrant and without any probable cause connected to an actual crime. The search turned up a minor technical violation the driver genuinely did not know about. He was charged and prosecuted. His attorneys took the case all the way up, and when it finally landed in front of all 9 justices, every single one of them looked at what the lower courts had allowed and said no. Not a close call, not a gray area, a clear and unanimous no. Here is the core of what the Supreme Court held, and I want you to understand every word because this is now your legal shield at every future traffic stop. The court ruled that the lawful possession of a firearm in a vehicle does not, by itself, constitute probable cause for a warrantless search under the Fourth Amendment. Let us break that into plain English. Probable cause means the officer has real, articulable evidence pointing to an actual crime. Not a feeling, not a hunch, not a theoretical safety concern, real evidence of an actual crime. A legally owned firearm is not evidence of a crime because owning a firearm is not a crime. The court said this clearly, directly, and unanimously. They went further. The justices specifically addressed the argument about officer safety. Yes, officer safety is a legitimate legal consideration, and the court has recognized that in previous rulings. But the court was unambiguous that officer safety concerns cannot become a blank check that overrides your Fourth Amendment rights every time a firearm is present. If officer safety alone were sufficient justification for a full warrantless vehicle search, the Fourth Amendment would effectively cease to exist for gun owners. Every justice refused to allow that outcome. What you need to feel the full weight of is the unanimity. Clarence Thomas and Sonia Sotomayor, sitting on opposite ends of the ideological spectrum, looked at this question and arrived at identical conclusions. When you have that kind of unanimity on a Second and Fourth Amendment case in today's political climate, the court is not making a close call. The court is saying this was never a legitimate legal question to begin with. The lower courts got it badly wrong. It required the highest level of correction. Now here is the part that most coverage of this ruling is completely missing, and it is the part that could still put you in handcuffs even with this ruling protecting you if you do not understand it clearly. The ruling protects you when your firearm is the only factor. Read that again. When your firearm is the only factor. The Supreme Court was precise. They did not say police can never search a vehicle where a firearm is present. They said the firearm alone is not enough. That distinction is enormous in the real world. The court reaffirmed a standard called the totality of the circumstances. What this means is that a judge reviewing a search will not look only at the gun. They will look at the entire interaction from the moment the officer first observed your vehicle. Did you pull over immediately, or did it take 2 miles? Were you reaching under the seat when the officer approached? Was there a smell inside the vehicle? Were you giving inconsistent answers? Were you displaying behavior that goes beyond normal traffic stop nerves in a way a reasonable officer could specifically describe? The court made clear that while the gun alone cannot justify a search, it can become one piece of a larger picture. If the officer can point to multiple specific, articulable facts that together suggest criminal activity, the search may still be legally upheld. This is why your behavior during the stop is actually more important to your outcome than the legal ruling in your pocket. There are other factors that can still give an officer legitimate grounds to search. If there is visible drug paraphernalia in the vehicle, if there are odors associated with controlled substances, if you are a prohibited person and the officer has reason to believe that, or if there is genuine confusion about your permit's validity across state lines, any of these elements can combine with the presence of the firearm to build toward probable cause. This ruling is a massive, real, significant win, but it is not a force field. You need to know both what it protects and exactly where that protection ends. Let me explain the legal doctrine at the center of this because understanding it gives you a completely different level of clarity. It is called the automobile exception, and it is the doctrine that was being stretched far beyond its original meaning until this ruling reined it in. The automobile exception is a long-standing legal principle that allows police to search a vehicle without a warrant if they have probable cause to believe evidence of a crime is inside. Courts created this exception decades ago for a practical reason. Cars move. If an officer has to wait for a judge to issue a warrant, the vehicle and the evidence can disappear, so the exception made sense in its original form. The problem is that some courts and prosecutors began expanding this doctrine in a direction that was never intended. Their argument went like this. A firearm is dangerous. Danger creates officer safety concerns. Officer safety concerns are a form of probable cause. Therefore, a firearm triggers the automobile exception and the officer can search the entire car. Follow that chain of logic and you realize it would justify searching any vehicle belonging to any gun owner at any time for any reason, which would make the Fourth Amendment completely meaningless for roughly 100 million Americans. The Supreme Court severed that chain. They said clearly that the automobile exception requires probable cause of actual criminal activity, not abstract danger, not theoretical safety concerns, criminal activity, and legal gun ownership is not criminal activity. The exception still exists, but it now requires real evidence of real crime, not hypothetical risk connected to a constitutionally protected right. This matters because the automobile exception is one of the most frequently invoked doctrines in vehicle search law nationwide. By clarifying how it applies to firearms, the court effectively raised the standard for an enormous category of traffic stops in every state in the country. There is something else this ruling resolved that nobody is talking about, and I want to call it what it is. It solved what I call the honesty paradox. For years, gun owners faced a terrifying dilemma during traffic stops. If you told the officer about your firearm honestly and responsibly, some courts had interpreted that disclosure as justification for a warrantless search, so you were effectively being punished for doing the right thing. Your honesty was being weaponized against you. This created an environment where legal gun owners were afraid to be transparent, which made stops more tense and more dangerous for everyone involved, including the officers. The Supreme Court changed that math entirely. Your honest disclosure of a legally owned firearm is now a protected act. It is responsible behavior. It is exactly what a law-abiding citizen should do. And the court has made clear that this act of responsibility cannot be used as the trigger to strip away your Fourth Amendment protections. The ruling encourages transparency and actually makes traffic stops safer for everyone. Now, I told you at the beginning that I would give you 5 words. And before I do, I need you to understand something about why those 5 words exist and what they are actually doing legally, because if you just memorize the words without understanding the mechanics behind them, you will say them wrong or at the wrong moment, and they will not protect you. When an officer asks to search your vehicle, the Fourth Amendment generally requires either a warrant or your voluntary consent for that search to be legal. If you say yes, you have waived your constitutional protection. The search becomes valid regardless of what is found. It does not matter that you thought you had nothing to hide. It does not matter that you felt pressured. The moment consent is given voluntarily, the Fourth Amendment steps aside. So when an officer looks at you and says, "I'm going to need to search the vehicle just to make sure everything is safe," here is exactly what you say. "I do not consent to searches." That is it. Those are the 5 words. They are not aggressive. They are not rude. They are legally airtight. What those 5 words do is create a record. If the officer proceeds to search your vehicle after hearing those words, they are now required to justify that search based on independent probable cause that will hold up in court under the new totality of the circumstances standard the Supreme Court just reinforced. If they cannot demonstrate that justification through specific articulable facts beyond simply knowing you have a legal firearm, then any evidence discovered in that search may be suppressed, thrown out. The charges built on that evidence can disappear. Now here is the thing most people do immediately after saying those 5 words that destroys all the protection they just created. They keep talking. They explain. They justify. They say, "I just don't want any trouble," or "I haven't done anything wrong," or they start referencing Supreme Court cases they watched a video about. Every additional word you volunteer beyond those 5 is potential material for a prosecutor. Stay calm. State your non-consent clearly, and then stop talking. The side of the road is not a courtroom. Your attorney is where this ruling does its real work. There are 3 mistakes that gun owners make during traffic stops that undo every legal protection they have, and I want to walk through each one because they come from understandable places and they are completely avoidable. The first mistake is reaching. The moment you reach for anything in your vehicle before the officer asks you to, you have created a dangerous situation that no court ruling can fix in real time. Keep your hands visible on the steering wheel. If it is dark, turn on your dome light. Do not reach for your registration, your insurance card, your permit, or anything else until you have been specifically asked, you have told the officer where each item is located, and you have received clear confirmation that you may retrieve it. This is not just about legal protection. This is about coming home alive. Furtive movements are one of the most commonly cited justifications for escalating a routine stop into something far more serious. The second mistake is over-explaining. Many gun owners get nervous during traffic stops and begin talking to fill the silence. They explain where the gun is, why they have it, where they are going, what they were doing before the stop. Every word you say beyond what is legally required is potential raw material for a prosecutor later. Be polite. Be clear. Answer direct questions directly. If your state has a duty to inform, you can say, "Officer, for your safety and mine, I want to let you know I have a legally owned firearm in the vehicle and I have a valid permit. How would you like to proceed?" That is composed, responsible, and positions you correctly, but do not follow it with a stream of additional information driven by anxiety. The court just gave you real protections. Do not talk around them. The third mistake is arguing at the scene. I understand this impulse completely. You know your rights, you have done your research, and when an officer begins pushing toward a search that you know is not legally justified, every instinct tells you to explain the ruling, cite the precedent, and stand your ground. Do not do it. The side of the road at night is not a courtroom. Arguing with an officer in the moment does not protect your rights. It endangers your safety, and it complicates the legal defense your attorney will build afterward. State clearly and calmly that you do not consent to any search. Comply with every lawful order. Document every detail in your memory. The time, the location, the officer's name and badge number, exactly what was said, exactly what was searched. That documentation is the foundation of everything your attorney will need to turn this ruling into a real outcome in your favor. Let us step back from the specific facts of this case and look at what the Supreme Court was actually communicating at a constitutional level, because the message here reaches further than traffic stops. The court said explicitly that constitutional rights do not cancel each other out. Your Second Amendment right to keep and bear arms and your Fourth Amendment protection against unreasonable searches and seizures exist simultaneously. Exercising one does not forfeit the other. This seems obvious when stated plainly. Of course, your rights do not eliminate each other, but in practice, across courtrooms in multiple states for years, that is precisely what was happening. Law-abiding gun owners were quietly being treated as second-class citizens whose Fourth Amendment protections evaporated the moment they exercised their Second Amendment rights. A 9-0 ruling was required to end it. The logic the court applied here, that the exercise of a constitutional right cannot itself be treated as suspicious activity, has implications that extend well beyond gun ownership and vehicle searches. This is a statement about how courts must think about constitutional rights whenever they interact with each other, and coming from all 9 justices, it carries enormous weight in shaping future cases. For law enforcement departments across the country, this ruling demands real changes in training and operational protocol. Officers who were trained under older, lower court interpretations were not necessarily acting in bad faith. They were operating within legal frameworks their departments told them were valid. Those frameworks have now been replaced at the highest possible level. Departments need to update their training materials. Officers need to internalize that the presence of a legal firearm is a neutral fact, not an escalation trigger, not a magic phrase that unlocks additional authority. That institutional shift will take time, which means in the near term you will still encounter officers who are working under the old rules even though those rules no longer legally exist. That is the gap that your personal knowledge of this ruling is designed to fill. Let us also talk about what this ruling means for law enforcement training going forward, because that transition period is something you need to be practically prepared for. When the Supreme Court issues a decision this sweeping, it does not instantly reprogram every officer in the field. Training cycles take months. Policy rewrites take longer. Legal guidance filters down through departments at different speeds. Some officers in smaller jurisdictions may not receive formal updated guidance for a year or more. This means that for a real, meaningful stretch of time after this ruling, you will encounter officers on the road who are still operating under old assumptions the highest court in the land just declared invalid. They are not all acting in bad faith. Many of them genuinely believe they are following correct procedure. Your knowledge of what the law now says is your protection in those encounters. You cannot count on the officer knowing what you know. You have to be the one in that interaction who understands the current legal standard and who behaves in a way that preserves your rights and creates a clean record for your attorney to work with if it becomes necessary. There is also a real danger on the other side of this ruling that almost no one is discussing. This decision only protects you if you are actually a law-abiding person in possession of a legally owned firearm. The protection evaporates completely if you are a prohibited person, whether you know about the prohibition or not. And this is where it gets genuinely dangerous, because gun laws across America are a patchwork that is almost impossible to track in real time without dedicated effort. You can be a perfectly legal carrier in your home state and cross a county or state line and become, without intending to, someone in violation of local law. There are jurisdictions currently litigating whether specific parking areas, transit zones, or public lots qualify as sensitive places where carry is restricted. If you are in one of those restricted areas and an officer identifies your firearm, the gun is no longer a neutral fact. It becomes evidence of a potential crime. And at that point, this ruling does not apply to your situation. The search that follows may be completely legal. This is why staying informed is not optional. The Bruin Standard established in 2022 reshuffled the constitutional framework for evaluating gun regulations, and states across the country are still actively testing its limits through new legislation and new court challenges. Every one of those challenges has the potential to create a new local or regional rule that changes your legal status as a carrier without you ever receiving a notification. Here is something that should genuinely concern you. Studies on legal awareness among firearm owners consistently show that fewer than 1 in 5 gun owners can accurately describe the search and seizure laws that apply to them during a traffic stop. That means roughly 80% of the people legally carrying firearms in vehicles across this country right now do not fully understand what police can and cannot do. The ruling we just discussed is a major piece of that framework, but it is one piece. And the rest of the picture, your state's disclosure requirements, your permit's reciprocity status, the specific restricted zones in the areas you travel, those are all things you carry the responsibility of knowing. Your practical action plan comes down to 5 things, and none of them are complicated. First, look up your state's firearm disclosure laws right now, today, before you get back in your vehicle. Know whether your state requires you to inform an officer about your firearm, exactly when that requirement activates, and the precise language the law uses. This is not optional. This is foundational. Second, carry all your documentation and know exactly where each item is. Your permit, registration, and proof of insurance should be in locations you can describe to an officer before you reach for them. Third, practice saying the 5 words out loud. I do not consent to searches. Say it right now if you never have before. It needs to come out calmly, clearly, and without any trace of aggression when the moment actually arrives. The more natural the phrase feels to say, the more effectively you will execute it under the real pressure of a traffic stop. Fourth, if you believe your rights have been violated during a stop, document everything immediately afterward. Not later that evening. Immediately. The time, the location, the officer's name and badge number, the sequence of what happened, every word you can recall. That record is the difference between a fast legal resolution and a prolonged expensive fight. Fifth, find an attorney in your state who specializes in firearms law before you ever need one, not after something goes wrong. Knowing exactly who to call and having that number already saved is the difference between an effective, immediate legal response and a panicked scramble while you are still trying to process what just happened. What the Supreme Court handed every law-abiding gun owner in America is a stronger, more explicit protection than existed before. A 9-0 ruling that says your legal firearm is not probable cause, that your constitutional rights coexist and neither cancels the other, that your honesty during a traffic stop cannot be converted into the weapon used against you. That is a real victory, a historically significant one. But victories on paper only become victories in practice when you understand them, when you know how to invoke them correctly, and when your behavior in the moment does not inadvertently hand back every protection the court just gave you. The ruling exists in every courtroom in America right now. Whether it protects you specifically comes down to what you know and how you act in the 12 seconds after you see those blue lights appear in your mirror. Know your state laws. Carry your documentation. Keep your hands visible. Stay composed. Decline unlawful searches with 5 calm, clear words. Document everything if something goes wrong, and have an attorney's number saved before you ever need to make that call. The Supreme Court did their part. Now you know yours. My next video is a full state-by-state breakdown of every firearm disclosure law in the country, ranked from most to least restrictive. It covers every scenario where the rules differ from what most people assume, and it covers the specific states currently pushing legislation that could create new restricted zones affecting carriers without warning. If you are not subscribed, that information is not coming to you. Turn on the bell right now. Because in this legal environment, being 3 steps behind is not just inconvenient. It is the kind of thing that turns a routine Tuesday drive into the worst day of your life. Stay safe, stay informed, stay legal, and remember, your rights are only as strong as your willingness to understand them, exercise them correctly, and protect them at every opportunity. I will see you in the next one.